Our next distinguished guest is Suzanne Ambrose. Susan, Executive Officer of State Personnel Board since May of 2007. Her public service career spans over 30 years at 5 different departments in the state of California. Before her appointment in her current position, Ms. Ambrose served as a Director of Department of Fair Employment and Housing, DFEH. She has been a staff attorney, Assistant Chief Counsel with DFEH, and a Deputy Attorney General and Supervising Deputy Attorney General in the Attorney General's office. Ms. Ambrose has also worked for the State Controller's Office and the Chancellor's Office of California Community Colleges. She received her Bachelor of Arts from University of California, Berkeley, and her Juris Doctor degree from Pacific McGeorge School of Law. Ms. Ambrose currently serves on the Executive Committee of the Public Law section of the California Lawyers Association. She previously served as chair of the Executive Committee of the Labor and Employment Law section of California State Bar and a member of California Governor's Committee on Employment of People with Disabilities, the Division of State Architects Implementation Committee for the California Certified Access Specialist Program, and California Association of Workplace. She is a very accomplished person, to say the least. So please join me in welcoming Suzanne Ambrose. Ms. Ambrose, the floor is yours.
Okay, well, good morning. I'm happy to be speaking to you today about a topic that's near and dear to my heart, employment of persons with disabilities. As I'm sure you know, roughly 10% of the state workforce self-reports as a person with a disability. That's well below state parity and well below where we would like to be. While SPB no longer administers the state EEO program since it was transferred to CalHR in 2012, we do administer the civil service system as a whole. And an integral part of creating a highly qualified workforce is identifying and recruiting untapped and undertapped communities. The disability community is one of the most qualified and highly educated but untapped sources for the state workforce. We've been working from several different angles to reduce barriers to employment and increase representation of persons with disabilities. We've worked on a multi-year project with ACSED, the Department of Rehab, and CalHR, primarily under the Brown administration, to identify barriers and make recommendations to the administration on ways to increase employment of persons with disabilities in state service. The more notable changes we made as a result of that effort were in the LEAP program. Specifically, we created the hiring manager's report in which LEAP and non-LEAP candidates' names are merged together so that LEAP candidates are not identifiable. LEAP candidates are now appointed as limited term rather than TAU. And the length of the job examination period is now the length of the probationary period for the class. And lastly, we eliminated the probationary period upon permanent appointment to the class after successful completion of the JEP. Most of our efforts in this area, however, are focused on our compliance review program and to a lesser extent on our appeals function. So I wanted to talk primarily about those areas by first giving an overview of the compliance reviews we do of departments' EEO programs generally, and then DACs specifically, and then talk a little bit about reasonable accommodation, and lastly, our appeals complaints function. SPB Compliance Review Unit audits state agencies' EEO programs on a 3-year cycle, which doesn't mean that every department gets audited every 3 years. It just means that every department gets audited at some point during each 3-year cycle. So a department could be audited in year 1 of one cycle, and then in the following cycle, they get audited in year 3. So in that instance, there would be more than a 3-year gap between audits. As you know, Government Code Section 19790 requires all state agencies to have an effective EEO program that includes certain components. And our audits identify any deficiencies in those components. Specifically, we look at whether the program includes a policy statement committed to equal employment opportunity, procedures for filing, processing, and resolving discrimination complaints, including appealing the agency's decision, procedures for providing equal upward mobility and promotional opportunities to employees, and cooperating with CalHR and SPB by providing access to all required files, documents, data that we need in order to do our reviews. We also look at whether the EEO officer is at the managerial level, reports directly to and is under the supervision of the director of the department, and is responsible for developing, implementing, coordinating, and monitoring the department's EEO program. And then lastly, that the EEO officer monitors the composition of oral panels in departmental exams. Of course, an agency with less than 500 employees is allowed to have the personnel officer also act as the EEO officer. Our compliance reviews check to make sure that every EEO program meets all of these requirements. Over the past 5 years, we have reviewed 214 EEO programs and found 62% or 132 in compliance with all of the EEO requirements. And only 5 departments did not have an EEO program or policy at all. The remaining violations included 15 departments that didn't have the EEO officer reporting directly to the head of the agency, 11 departments that did not have the EEO officer monitoring the composition of oral exam panels, 8 departments that did not have an upward mobility plan, 5 EEO officers who did not have a duty statement on file which reflected EEO duties, 2 EEO officers who were not at the managerial level, and 2 departments that inappropriately had the personnel officer acting as the EEO officer. Now, with respect to the department's disability advisory committees, as you know, under Government Code Section 19795, every state agency must have a disability advisory committee that's comprised of employees who are individuals with a disability or who have an interest in disability issues. And the DAC must advise the head of the agency on issues of concern to employees with disabilities. The EEO officer provides leadership and guidance to the DAC and is responsible for ensuring the agency establishes and maintains an active DAC. Of the 214 reviews conducted over the past 5 years, almost 20% or 40 of the agencies did not have an active DAC at all. This is the most common deficiency in our reviews in the EEO area. Many of those departments are micro agencies whose administrative services functions are performed by another agency, and they just simply were not aware of the requirement to have a DAC. We've worked with some of these micro departments in having them get together with other agencies to form a multi-agency DAC. So, for example, the state treasurer's office has a number of small, commissions, authorities, boards. And so in that instance, several of those have gotten together and joined the state treasurer's office disability advisory committee. This is usually facilitated by the EEO officers of each department getting together to form a multi-agency DAC. Each agency invites all of its employees to join the DAC so that there's at least one employee from each of the agencies on the committee. The DAC then reports to each agency head on concerns impacting their employees. There's no real prescribed manner in which the DAC provides recommendations to the agency head. But through our audits, we've, come up with some best practices. So some departments have the EEO officer conveying DAC recommendations to the agency head during regularly scheduled meetings. Some departments, the DAC meeting minutes reflecting the recommendations are provided to the agency head either by email or memo. In some cases, what I like to do is meet with the DAC chairperson on a regular basis, usually quarterly. In multi-agency DACs, it could be the employee representative from that particular department that reports back to the agency head, or the agency head can always attend the DAC meetings and receive a briefing that way. So I wanted to talk a little bit about reasonable accommodation. As you all know, both state and federal law require departments to provide reasonable accommodation to applicants, employees, and customers with disabilities. Who's responsible for the reasonable accommodation function varies by department. In larger departments, you'll have a reasonable accommodation coordinator. In smaller departments, it'll be the EEO officer. And in micro departments, it just might be the HR office. When I was director at DFEH, we actually formed a reasonable accommodation committee comprised of the EEO officer, the HR director, the chief counsel, the procurement officer, and the enforcement division deputy director. The committee met monthly, and the idea was to ensure that requests for reasonable accommodation were being reviewed and responded to timely, and that reasonable accommodations were being provided timely, effectively, and consistently. Once a reasonable accommodation was in place, the committee monitored the reasonable accommodation to make sure that it was still appropriate. For instance, if the reasonable accommodation was time limited, like a temporary modified work schedule, the committee would ensure that when the end time for the temporary schedule came up, that it was terminated and that the termination was clearly communicated to the employee and the supervisor, or the employee was provided, the opportunity to provide additional justification to extend the reasonable accommodation time period. We were trying to avoid situations where that were happening all too frequently, which was a reasonable accommodation would be put in place and then nobody would check back ever to see whether it was still needed, whether it was effective, whether there was something else that needed to be done. Regardless of how the department structures its reasonable accommodation function, the EEO officer is responsible for ensuring that reasonable accommodation process is being utilized properly and for monitoring the effectiveness of the reasonable accommodation policy and program. As I mentioned, hiring departments are responsible for providing reasonable accommodation during all stages of the selection process. And that includes the examination, the hiring process, and then, of course, the probationary period. With respect to exams, obviously, the department is only responsible for its own exams, not service-wide exams administered by CalHR. The department is responsible, though, for providing reasonable accommodation during all components of the hiring process. So if, for instance, as part of the hiring process, the hiring manager has the applicant perform a writing exercise prior to the interview, the hiring manager needs to provide reasonable accommodation to perform the writing exercise if needed. So when scheduling the interview time slot, it's a good idea to inform the applicant about the writing exercise so he or she can request an accommodation in advance if needed. Some classifications have skill requirements, such as the ability to type 40 words per minute. Prior to GRP1, when SPB still had the selection division, SPB administered the typing test. But once that function transferred over to CalHR, applicants were referred to external agencies such as one-stop centers to obtain typing certification. The problem is that there's no way to ensure that these external sources provide reasonable accommodation, and there have been instances where the applicant has not received a reasonable accommodation by these external sources. Since it's the hiring agency's responsibility to ensure reasonable accommodation in all aspects of the hiring process, if an applicant does not provide a typing certification as required for the classification, the hiring department should administer the typing test at the time of the interview, either before or after. And I've recently met with CalHR regarding this issue. They're going to be issuing some guidance to departments to this effect. And they're also looking into reestablishing the typing test through CalHR for those applicants who have a job offer. Since the probationary period is part of the selection process, it's critically important that timely and effective reasonable accommodation be provided to ensure that every possible barrier to successful performance is removed. The probationary period is the time when the employee is trained and evaluated to determine whether he or she can meet the performance expectations of the job. If an employee is not progressing at the expected rate, the supervisor should explore what, if any, barriers are impeding the employee's progress and work with the reasonable accommodation coordinator to try to eliminate those barriers. Probationary periods can be extended for purposes of providing reasonable accommodation upon the executive officer's approval. In order to do that, the department needs to have a written agreement between the employee and the department. The extension can't exceed 6 months. The agreement needs to set forth a beginning and ending date, and the agreement needs to describe how the extension will allow the employee to demonstrate successful performance prior to the end of the extended period. Probationary periods can also be extended when the employee's missed a certain amount of work time due to absences. That's a different process. Lastly, I want to talk just briefly about our appeals. Prior to GRP1, state employees could file discrimination complaints with SPB on any protected basis, but GRP1 eliminated that option for all but disability and medical condition complaints. Currently, state employees can file complaints with SPB alleging a denial of reasonable accommodation or discrimination based on disability or medical condition, in addition to filing with DFEH and EEOC. In the last 5 years, we've accepted 58 complaints of disability discrimination. And in order to file with us, the employee must first file an internal complaint with the employee's EEO office within 1 year. The appointing authority must provide a decision within 90 days of filing. The employee then has 30 days from the date of the decision to file a complaint with the SPB Appeals Division. If the department doesn't render a decision within 90 days, the employee can file a complaint with SPB, but must do so within 150 days from the date of the internal complaint. We schedule discrimination complaints for full evidentiary hearings before an administrative law judge, and the employee has the burden of proof. Keep in mind that the employee does not have to file with SPB before filing with DFEH or EEOC, and the employee can file simultaneously with both SPB and DFEH EEOC. As part of our compliance reviews, we audit departments' compliance with the complaint processing requirements. Of the 214 reviews we've conducted in the past 5 years, 15 agencies were found out of compliance by either not issuing a decision within 90 days or failing to notify the employee of the delay. So that concludes my prepared remarks. I'd really like to hear from all of you if you have any questions for me.
Thank you.
We have someone in the comments asking if you can repeat the complaints process. I'm sorry, Bobby, I just spoke over you.
No, go right ahead.
Oh, sure. The discrimination complaint process. Let's see. So they have to first file an internal complaint with the employee's EEO office within 1 year. The appointing authority has to provide a decision within 90 days of the filing of the complaint. The employee then has 30 days from the date of the department's decision to file a complaint with the SPB Appeals Division. So it's basically an appeal of the department's decision, but it's actually technically a complaint with us. If the department doesn't render a decision within 90 days, then the employee can file a complaint with SPB, but that has to be done within 150 days from the date of the internal complaint. So that's the procedure. Oh, go ahead.
No problem. Sorry. Thank you so much. We unfortunately are a little short on time. I want to does anybody want to unmute and ask a question to Susie directly? And then we may have to do any follow-up questions in a later email if you send it to SDAC, and we'll get to them. Does anybody want to ask a question?
Yes, I have a question to ask. A lot of times people don't complain for a while because they fear that they might lose their job, so they don't want to complain at all. and then when they are about to, or they change departments or move on, that's when they start the complaining process, because then they feel they are safe now. Nothing would be retaliated or some other softer way of taking action against the staff. So they keep quiet for a while. So is there a statutory time limitation in terms of filing a complaint or concerning discrimination?
Yes. So if the complainant wants to file with SPB, they have to file with the department EEO office first. Okay. And that has to be filed with the department EEO office within a year from the act of harm. Okay. Now, if they don't want to file with SPB and they just want to go straight to DFEH EEOC, they don't have to first file with the department EEO office, and they don't have to file with us. They can just go directly to DFEH. So I hope that answers your question.
Ms. Ambrose, this is Bobby here. A couple of questions. One just came through the text chat, and the questioner is asking, is there a specific time frame the agency must respond to a request to a reasonable accommodation? In other words, what's the interactive process reasonable time frame?
Yeah. So they should respond immediately. Okay. And so they should engage in the interactive process immediately. Sometimes it, takes a while because the employee has to get, medical documentation. There might be a delay in connecting with the, healthcare provider. And so it really depends on what the specific accommodation is to determine what's really reasonable, right, in terms of a time period. If we're talking about some kind of equipment, that should be procured immediately. There should be a process set up so that, the reasonable accommodation equipment, most of it, the vast majority of it is available today. There are some instances where it might be more complicated. It might be some very unique or sophisticated type of equipment that needs to be ordered. But there really shouldn't be any kind of delay. And the interactive process needs to commence immediately. I mean, I would say, within the same day that it's made, there needs to be interaction and, actively pursuing it. So we don't like to see, big delays for no reason. And then, always check back with the employee if it's taking some time to obtain the reasonable accommodation, whether it's, some kind of certification or some kind of equipment. Find out what can be done in the interim and work with the supervisor and the, healthcare provider.
So, Susie, this topic of the time frame of the reasonable accommodation is a repeated topic in our SDAC meetings. And because we have little time, is there any way that we could maybe do a follow-up meeting or discussion with you or someone from your team about this in our SDAC? Because this is a really hot topic for us, for many agencies, about negative experiences with it took too long or it feels like we're not making any progress. And it's hard because each agency, we hear should be quick, but also that it's dependent on the circumstance.
Yeah. And, I'm happy to join in on those discussions, but this is really an area that is under CalHR's jurisdiction. And so I would just like, them to be included in the discussion so that, we're just all on the same page. But yeah, I'm happy to participate.
Great.
Bobby, do we want to take one more question? Or do we want to? Yeah.
One other question that comes to SDAC quite frequently, and you actually touched on this earlier, there's small micro offices, agencies, entities that don't have the ability to form a DAC because there's only 3 people in the office making it up, and they want to cooperate. Logistically, what would be the process? Could they change their bylaws and have the other cooperating agencies change their bylaws to accommodate that, or what's the best practice for that?
Sure. Yeah. And this really comes up frequently, actually. In fact, SPB and CalHR have a joint DAC. So our DAC and so we do it jointly. We had a department recently that has the executive director and an SSA. That's the entire staff. And so, basically the question that staff had for me was, well, can we let them have the SSA be the, the EEO officer? Okay. And so, basically I just said, what agency are they part of? Look to see if there's some other agency above them, an umbrella agency or who does their administrative services. Because obviously they don't. They have someone else doing it. Is it DGS? See if they can join that one. So with the DAC, it's similar. When you don't have, in a situation like that, if the SSA doesn't want to do it or isn't interested in disability issues, you're not going to have anybody in your organization that can, participate. And so you can just see if, the department can join another department, maybe a sister department, an agency, and just be, connected that way. The idea is that the head of the organization needs to have access to information about their, their work site. And obviously, if there's just one person in the office and that person has an issue, that's an easy communication. But also, we have an obligation to provide reasonable accommodation to our customers, people who come in, people who use our services. And so, that's also something that the agency head needs to be aware of and should be getting that information through their DAC.
Great. Thank you so much. Really appreciate Ms. Ambrose for a very informative presentation. And please accept our gratitude for being here. We might want to follow up with you by way of an email with any residual question, if that's okay.
Absolutely.
Great.
My pleasure.
Thank you so much. And have a great day.
Okay. You too.
All right.
Bye-bye.